In terms of the overview of our talk, we're going to look at the shareholder claims market, the context to this and some of the background. We will look at the types of claims that are available to shareholders. We'll give an overview of some of the key cases that there have been to date in England. We'll look at some of the common practical and legal issues that arise in these types of cases. And we'll give a view on the outlook as to how things are shaping up into the future. Looking first then at the shareholder claims market, well, there's certainly a growing market for English class actions generally, and in particular in the shareholder class action space. And why is that? Well, one of the reasons is because of a US Supreme Court decision in 2010 in the case of Morrison against National Australia Bank. And that was a very important case which had wide ramifications for securities litigation in other jurisdictions outside of the US. Because what the US Supreme Court decided was that it was not appropriate for US courts to hear so-called F-cubed cases. And what we mean by an F-cubed case is foreign investors suing a foreign issuer trading on foreign exchanges. And the Supreme Court in the Morrison case decided that really the US court should only be dealing with cases that related to transactions in securities listed on domestic US exchanges and to claims related to domestic transactions in other securities. And it shouldn't be this central forum for all comers, essentially, to bring their securities litigation. So that was 2010. And what we've seen since then is a rise in securities litigation in other jurisdictions, England included, after that decision.
Because what Schedule 10A provides is a definition of what a PDMR is. And the definition is basically any director of the issuer or person occupying the position of director by whatever name called. In the case of an issuer whose affairs are managed by its members, any member of the issuer. And in the case of an issuer that has no person, which is either a director or a member, that's when you can then say that a senior executive of the issuer having responsibilities in relation to the information in question or its publication can be a PDMR for the purposes of establishing liability under this regime. And what the sort of court held in this situation, there were those two issues. One was, well, who is actually a PDMR, and can all 5 people that the claimant identified be PDMRs?